where that case had the proposition that when the vehicle is in a safe position outside of the possible collision, that's no longer being operated at that. I know the people rely primarily on MCL 764.15 specifically, I believe it was subsection G for the statute that allows a warrantless arrest if the officer has reasonable cause to believe the defendant or suspect has committed a misdemeanor punishable by up or greater than 92 days. One question that I know I had when reading through the case law cited by defense as well as the case law cited by the people is why that statute was not referenced in Woods.
Or it does call the case, People versus Aaron Williams.
When you're on Raymond Cook for the people.
Michael Vincent, on behalf of my client. Sir, come on up. State your name, Judge.
Aaron Williams.
This is the date and time separate. Pressing dismiss, I believe we're set for evidentiary hearing.
Well, we're not set for an evidentiary hearing yet. Sure. But it's their motion. Yes.
That's my mistake. I thought we were set for an evidentiary hearing today.
Yeah. It was whether or not there should be an evidentiary hearing is actually how we are. Mr. Vincent, did you have anything else to add other than what's contained in the motion?
No, I don't, Your Honor.
This whole case comes down to one legal question. Was this arrest even legal? Everything hinges on whether the car was on the roadway and whether the trooper had the right to make a warrantless arrest. It's about to get very technical, very fast.
Anything else from the people?
Briefly, Your Honor, I did want to draw one additional distinction. I know the court's read the motions as well as the case law. I specifically want to draw the court's attention back to the case defense counsel cited People v. Woods, where that case had the proposition that when the vehicle is in a safe position outside of the possible collision, that's no longer being operated at that. I know the people rely primarily on MCL 764.15 specifically, I believe it was subsection G for the statute that allows a warrantless arrest if the officer has reasonable cause to believe the defendant or suspect has committed a misdemeanor punishable by up or greater than 92 days. One question that I know I had when reading through the case law cited by defense as well as the case law cited by the people is why that statute was not referenced in Woods. My research and understanding, Your Honor, is that the statute was actually amended after Woods to allow for that exception, which draws further distinction between this instant case and the case cited by defense for their proposition. So I just ask the court to again consider that when the court makes it. Thank you.
Anything, Mr. Vincent?
I think there's some questions that need to be asked, regarding the whole interaction between the trooper and two female, for instance, my client and my client. Particularly, there is a video that should be played and questions should be asked.
Regarding
what happened on the side of the road.
Well, one of the questions I do have, and I don't know if counsel can answer it, is if there's a question, and I think it's indicated in the statute about being on the roadway. One of the things I saw, part of the distinction between what defense counsel and was arguing and what the people had asserted is, and I guess maybe part of it can be answered, and I don't know if we've changed the analysis, is what is the roadway? And the roadway under the traffic code has a specific definition. I don't have it in front of me, but that was one of the issues. And I don't know, I'm familiar with the area of I-94 near State. I'm not sure specifically where they're located, which might answer the court's question or not. I was also, frankly, a bit curious, and if it indeed happened, but it certainly was indicated by the defense that that the vehicle was stationary, and then at some point, and I don't know if it was running, I don't think that was necessarily indicated, but at some point then the trooper asked the defendant to move the vehicle. I don't know, and it's not really stated in here, why that particular thing occurred in the case. Suffice it to say, in my mind, I think, and I understand the references to the statute, but I think to apply the statute, I need the factual circumstances. So what I am going to do is I am going to grant an evidentiary hearing in this matter. So I'll grant the motion. When do we want to do this, and when would the troopers and others be available?
Your Honor, I thought that we were going to have an evidentiary hearing. My trooper is present today. If the court wants to conduct testimony, the defense counsel is prepared. I am ready to proceed with that hearing immediately, or I can ask the trooper for her available dates in the future if the court and defense want to set this out for a separate date.
There's at least one civilian witness that, according to the police reports, that talked to the trooper about my client. And I don't believe she's here today. So
Is that I don't know what every party was. Was that the girlfriend?
I believe
Or,
defense counsel's referring to.
because I think, weren't there two women there?
Yes.
Outside of the trooper. There was the individual with the flat tire, which is the mother of the girlfriend.
I believe that's
At least how I picture it and what I'm reading. And then the girlfriend. So you're referring to whom, Mr. Benson, in terms of, so there are two civilians outside of the defendant. I'll suffice it to say that. Which one are you talking about?
Your Honor, it should be Angela Ray Perry. That's on my page 9 of the state police report. Contact with Aaron's girlfriend, the parentheses, Angela Ray Perry.
Okay, and your position would be that the people should secure that witness. Or
Yes, but perhaps I talk with, prior to our hearing, whenever that's going to be. I don't know how available she is, or if we can make some sort of agreement about what's in the police report that won't be in the hearing. Trying to be delicate right now. And I know myself and
Well,
oxymorons, but
me, just ask this, since it's at the point of an evidentiary hearing. You said it was a conversation that she had with the trooper.
yes,
I'm going to presume, and I don't know, you guys have seen the evidence, I haven't seen everything, that any conversation that she's having with the trooper is going to be on Bodycam. And we, with or without her being present, we're going to know what that conversation was.
but I would like to, if that conversation is going to come in, I want to be able to cross-examine her as to what she said and why she said it and when she said it regarding this. And it's
Okay. Right. And I'm not.
Two witnesses, the girlfriend and her mother, were both right there when the flat tire happened. Defense wants them both in court, but the prosecutor is questioning whether their testimony even matters to the legality of the arrest.
That's fine, I guess. So it isn't necessarily entirely the substance of it. You want to cross-examine her as to certain,
yes,
as to maybe meaning or whatever. Okay, I get it.
and the mom, also both of the two ladies raised just eyewitnesses. I mean, they saw and heard what's going on, and there is some issues that we had.
Okay, let's assume all that to be true for the sake of protect. Go ahead. Mr.
I can try and get those witnesses. The concern that I would have is I believe the testimony or the statement that defense counsel is referring to was given by the girlfriend after the arrest of the defendant. And if the court is conducting an analysis as to the reasonableness of the arrest, I'm not sure how much we can use that post-arrest statement to justify the arrest. Maybe that's a better argument for when we get to the hearing itself. Again, if the defense wants that, we
I
can
don't
get
think
there.
it's that clear. And
Pardon?
I don't think it's that clear.
Yeah, I think the statement was with reference to, and I don't want to get too specific because I don't know, but it's in reference to the consumption of alcohol.
Yes, and that statement was made after the defendant was arrested. And so for challenging the validity of the arrest, I don't know if that's going to be relevant to a consideration, given that the trooper would not have known that information at that
Time.
I'm not sure the prosecutor is correct on that. I don't know. Right.
Okay.
I will get that witness.
Okay. All right. So, and just so that we're clear and not getting here and then all of a sudden it's not. Mr. Vincent, are you saying that both witnesses should be here? Or both? Yeah, both of you.
All people involved witnessing what went on should be here.
But what relevance would I think I'm going to say the mom or the driver of the vehicle, what relevance in any way would she have to the issue of
I think she would be able to testify condition of my client, and also she would be able to testify as to interaction between my client and the state trooper.
But just by way of profit, what is she going to tell me about that interaction that I'm not going to be able to see?
I'm not sure what you'll be able to see on that part of the video. It's a body cam. The three people are sitting in a car. The car's parked with the headlights facing west into eastbound traffic. And this part of the video, which may or may not be played, my client's trying to change a flat tire.
I kind of get that picture, but you're saying that the mom would be able to tell me something about the interaction that the trooper had with the defendant.
Possibly with them.
But I mean, right. I hear you, but it seems to me
I may not need that. But possibly we could work something out with if that's not needed.
okay, because I mean, I did not see anything in the motion where even tangentially, that the trooper's decision to arrest had anything to do with any interaction with the mom. I saw no reference to that.
I agree. But
Okay.
I'm saying the register.
As opposed to the daughter or the girlfriend, where there is this statement, but now I'm a bit, I assume the statement occurred at an earlier point, but the people are telling me that it's at a later point. I don't know.
The mother referred to her last name is Jacques, is a red flag witness.
She's there clearly would be a race just eyewitness, but I don't know what they would add for this court's determination of whether or not the arrest is proper and whether or not
It's possibly probably be more appropriate for a trial.
Right. I don't have a doubt that person might need to be a trial. Everybody who was there would have to be a trial if it proceeds there. But I
understand where the court's going.
good. So
No, I don't think the mother needs to be here for a hearing.
okay, girlfriend. All right. And the people, since it's their burden, will secure that one.
Yes, Your Honor. And
All right.
I will ask my trooper what days she's available.
Yeah. Whatever.
Are these always set on Wednesdays, Your Honor? I'm not familiar with the court.
Troopers are available around the clock 24/7.
I know. But
So
I want
that's why I love to live in this state, because they're everywhere. And there is a certain peace one has when you see the bubble. Anyway, what?
First schedule, does the court typically schedule evidentiary hearing on Wednesdays?
I usually, what day can I? My next date, unless you guys want to do it sooner, would be June 24th at 9 a.m. And I don't mind trying to pick a date earlier, but you were here yesterday, so I now am full of.
I'm going to be here 5 days a week next week, so I'll be.
Are you?
Yes.
Well, welcome. We should have lunch. No.
I've got another motion on that date,
What date?
24th of June.
You got another motion? Okay, hold on. So why did they send you here alone? Well, Ann, where's Ann?
They had a lot of extracurricular activities going on today.
They what?
Extracurricular activities going on today.
Ooh, your office?
All my guardians.
Ann?
Yes, Mr. on June 20th.
He is, okay.
I don't know that we have that motion yet, but you did give him that date.
I gave him that date on another case.
On another case, yes, sir.
We can just move.
And that's in your calendar?
The 24th works for my.
It's like a blind squirrel finding a nut, but that's great. What?
The 24th works for my trooper. I don't know about the labor this whole subpoena her anyway.
Okay.
So if we could just move down to a couple of minutes.
If we could do what?
I have a motion in besides this gentleman, Mr. Downer.
On the 24th.
Yeah.
And so what do you want me to do? So I can tell you no?
Been married a long time, Your Honor. I'm used to the word.
I'm not, I am not going with you on that. Evidentiary hearing in this matter will be set then for June 24th, 2026 at 9
Yes.
And
a.m.
I'll file necessary papers to adjourn Mr. Downer.
Why? You're here on the 24th. You can do two things.
Sir.
I can. But
What?
oh, I can.
We also have a blood test was taken. He has a tether on there. Blood test today, 0.08. Is there any possibility of getting this tether?
I set the condition and realized the blood alcohol content was 0.083 as alleged, but I also have an indication that there's a prior.
You may be right.
Oh, I'm right. So, in reference to that change, I'm not going to change that bond condition. Anything else?
Nothing from people, Your Honor.
All right.
If at an appropriate time, I need about another issue.
All right. Very good. Thank you, Drew.
The judge sets the evidentiary hearing for June 24th and denies the request to remove the tether, given the defendant's prior OW1 record. If you want to see how this one plays out, subscribe and turn on notifications.